Welcome everyone to the Tennessee Pretrial Symposium series. This video is titled "A Judge's Insights on Safe and Effective Pretrial Alternatives." We're very lucky to have joining us today Judge Ronald Adrian from Cleveland, Ohio, who has tons of experience on these issues and is going to be sharing his insights with us today. My name is Quentin Weld. I'm a policy specialist from the Crime and Justice Institute. The series is funded by the Tennessee Office of Criminal Justice Programs. The OCJP is committed to improving pretrial systems throughout the state of Tennessee and started this series to provide helpful information to jurisdictions as they start making changes to their local pretrial systems. So a little bit more about CJI, where I work for. CJI provides criminal and juvenile justice training and technical assistance nationwide, and is partnering with the OCJP to make this video series happen. And like I said, today I'm here with Judge Ronald Adrian to talk about his experience implementing alternatives to traditional pretrial justice in his jurisdiction. And this is a pretty broad topic, so we'll focus on alternatives to pretrial detention and financial conditions. So Judge Adrian, just a little bit more about you. You served as a judge in Cleveland for 36 years and have a ton of experience in this area. After beginning your career as a prosecutor, you decided to become a judge. And just to mention a couple of your accomplishments on the bench in Cleveland, just the numerous reforms that you led to court process there, including the development of special dockets for defendants with behavioral health issues and veterans. You chaired the Ohio Commission on Racial Fairness for a number of years, organized workshop for judges on how to better protect DV victims. The Family Justice Center, a social service office for survivors of domestic violence that opened in 2014. And then most relevant to this discussion probably is being a leader in these recent reforms that reduce the number of folks detained pre-trial in your jurisdiction because they could not afford bail. I wanted to ask you a little bit about the reasons why jurisdictions might want to look into pretrial reform and some of the state of things at the moment that mean that pretrial reform is a good idea.
Yeah, well, first of all, it's cost effective. Having a pretrial reform protocol means that you reduce the number of people that you have in jail. Each one of those people is costing you money to not only house them, but to feed them, to medicate them, to clothe them. The fewer people that you have there, the more money that you have in your coffers. You know, the United States of America, unfortunately, represents 5% of the world's population, but also 25% of the incarcerated people in the world. You know, that's a number that, you know, doesn't make a whole lot of sense, you know, in the grand scheme of things. Nearly 10.6 million people are admitted to the nation's jails each year, and at any given point in time, some 750,000 of those people are detained. And the majority of those people are being detained in jail and are being detained pre-trial. It doesn't make a lot of sense for us to continue to have our stats like that, especially when a significant number of that population is being detained pre-trial are people of color. So there are reasons why we need to get away from the things that we've done before. There's a lot of unintended and implicit bias at every level of the criminal justice system. And, you know, that's not just me saying that, that's what the researchers have found when they've gone in and they've taken a look. And that being the case, we have every reason to try to scrutinize every decision that we make to make sure that that type of bias is not causing people to find themselves being negatively impacted by the system greater levels than they should be.
I know that you implemented the Arnold Ventures public safety assessment and used that to expand a series of alternatives to jail. If you could talk a little bit about that experience, I guess, first.
You know, I mean, as I said, I spent a long time on the bench, and for the majority of that period of time, I think like most judges, I was more interested in the trees than I was in the forest as it related to folks coming through the door and making sure that I processed them, you know, giving them what I thought was basically due process and getting them out of there as quickly as possible, because I had a whole lot more behind them that I had to deal with. In late 2015, I got a rare invitation to participate in what was called a convening by the U.S. Department of Justice and the White House. And this convening took place in Washington, D.C. There must have been about maybe 200 or 300 of us who came in from all across the country to talk about things having to do with pretrial issues and also post-disposition issues dealing with fines and fees. So bail on the front end, fines and fees on the back end. And we were there for 2 days. And I have to say that those were probably 2 of the most impactful days of my entire career, because by the time I got through with that, I was looking at myself and thinking, darn, I've been doing this wrong for the majority of the time that I've been on the bench. But what they basically were able to show me was that individuals who were subjected to low, or I should say short levels of incarceration suffered significant and in many instances severe impacts that brought them back into the criminal justice system and also caused them to have all kinds of negative repercussions. And this was particularly true for individuals who were charged with low-level, low-risk offenses. And they were able to point out that when you're dealing with people who basically don't have a pot nor a window, and you cause them to spend as little as 3 days incarcerated, that 3 days can actually ruin their lives. And the majority of the time that we spent listening to the experts, because they had researchers that laid out what the research was across the boards, the more kind of both depressed and energized I became. I was depressed in thinking about how many people I had just, as a matter of course, required to spend those kinds of short periods of time in jail, and some of my own internal and implicit biases as I related to people who didn't have a whole lot of money, and how those biases played out in judgments that I made. And all of that caused me to do some really deep introspection as to what I needed to do when I got back home. As a result, by the time I finished up, I had made up in my mind that I was going to take a run at trying to bring about some reform in the way that my court handled pretrial issues, which I thought really probably were not on the minds of most of the other of my benchmates, just like they weren't on my mind. And so the idea for me was to bring back to Cleveland the information that I had received, plus any additional information I had, and to come up with a game plan as to how we could bring about change. And so my process was to come home, put together a document that I could share with my peers, shop it individually with them to kind of let them know what I had seen and to try to get some buy-in from at least a majority of them about the need for change, and then to provide them with a vehicle by which that change could be made.
So what did you do after what first steps did you take in your jurisdiction to address that?
So I went back, and the first thing I did was to take a look at the bail schedule. We revamped the bail schedule to allow all people who were charged with low-level, low-risk offenses and who didn't have any other outstanding warrants to be released from jail on their own recognizance. And it's not like that was a universal kind of buy-in from all of the judges of the court. We had a couple who were really kind of not on board with that. We tried to get 100% consensus, but at the end of the day, out of the 13 judges, we had about 11 who were okay with it. I convinced them to try with the low-level and low-risk population, sort of as a pilot, to see what would happen, because I figured, and I was able to convince them, that if we tried it with that population, even though we didn't have a risk assessment, we would be able to see pretty rapidly, A, whether or not people would come back to court, and B, whether or not they committed new offenses. What the research had suggested that I had seen by then was that the vast majority of the people would come back to court, and they would come back to court without having committed an additional offense. I layered on top of this the fact that in looking at the population of people who were coming into municipal court charged with misdemeanors, that the majority of them were charged with traffic offenses. So we had people who were charged with driving under suspension and no driver's license and other offenses of that nature, DWI, who were coming in, didn't have the money to get out of jail, were spending 2 or 3 days at a minimum before they saw a judge. And as a result, having all of these cumulative disadvantages heaped upon them because of the fact that being in jail meant that they missed work, which in the case of somebody who is on the low end of the spectrum probably means that by the time they got out, they didn't have a job waiting for them. And that in turn meant that their housing was at risk, and that in turn put their family at risk, and that in turn put their possibilities for healthcare at risk, and on it went. So, we decided to pilot the low risk, low level misdemeanors to see how that would work. And I held my breath and I hoped for the best. And fortunately, that turned out extremely well for us. We had, on average, somewhere between 150 and 167 people at the workhouse every night. Within 6 months of implementing this new process, that population had dropped to just under 100. And over the next few months, it went even further below that. So we could show that we were putting people out on the street, but the next consideration and concern was whether or not those people would come back to court, and somewhere in excess of 85 to 90% of them did. And they came back without having, in that period of time that they were at liberty, committed any appreciable additional level of offense. So we did see, some people, I'm not going to say it was 100%, but it was really in the low single digits. So it was not that different from what it was when we were locking everybody up. After we implemented it, we recognized that there were some things that we needed to do if we were going to expand that beyond just that low level, low risk population to a population where the risk was somewhat higher, and that we didn't have that for those particular tools in place yet. One of the tools was a validated risk assessment tool that would allow us to gauge as well as humanly possible the risk that each person really presented when they appeared in court of either not showing or committing some new offense while they were out and about. So the low-hanging fruit was low-level, low-risk offenders with no prior, other kinds of things hanging out there, warrants or warrants. But if we were going to move beyond that, then I had to actually try to identify some sort of a vehicle that would give us that risk assessment. Since I've left the bench, I know that they've expanded on what I tried to bring in when I was there, so that they can use the PSA for people who are charged with felony offenses. And they're starting with low-level felony offenses, but ultimately they want to move up to the point where they can use the PSA to help them make decisions about people who are charged with more serious felony offenses.
You've mentioned the risk assessment a couple times, and a few Tennessee counties are in the process of implementing one or looking to implement one soon. I wonder if there's anything more you could say about whether or not that information is helpful to you when you're on the bench and how it's helpful to you when you're on the bench.
When you are a judge, you can ultimately make all of your decisions based upon your own attitude. This is a tool, a risk assessment. It's not the end all and be all. It does not put you in a position where it can make the decision for you. You don't just put the numbers in and it spits out the number and that's the number that you should use. Every judge is going to make every decision as it relates to those folks who are charged with offenses before his bench based upon an amalgam of the tools that he has available. This is just one of them.
How about the limitations of risk assessments? I know that there's been some talk across the country about how they're not, of course, a perfect solution. And do you have any thoughts on the limitations of risk assessments?
Sure. As with any tool, it's going to have limitations. One of the things that people have talked about across the country as it relates to it is that, and not necessarily the PSA so much, although that too has been questioned, is whether or not it can be used in a way that's racially discriminatory. The primary reason why folks have an issue with risk assessments has to do with the fact that most of them use prior offenses as one of the elements that are used in order to try to come up with a score. Minority individuals live in communities that are more highly policed than others. And so as a result, there's a higher probability that minority males in particular are likely to have a higher number of arrests within a set period of time that would go into the makeup of the score. Doesn't necessarily mean that they're more dangerous than someone who lives in another community that's not as highly policed. The fact that they have that reality makes people in minority communities kind of not that what's the word I'm looking for? Not feeling that good about risk assessments per se. And of course, different risk assessments have higher or lower propensities to reflect the potential for that bias. The other bias that you hear people speak of when you're talking about risk assessments has to do with their ability to be predictive as it relates to folks who are involved in intimate partner violence. And in many instances, most of those tools are not useful, and that includes the PSA, in addressing questions having to do with intimate partner violence. The way that we tried to get around that failing was to layer on top of that other tools that that actually gave you better information about intimate partner violence, like Dr. Jackie Campbell's dangerousness assessment, which really is more victim-based than perpetrator-based. And so you get both sides of that coin when you're making your decisions. And again, I go back to what I was saying before. These things are tools. They are not, fail-proof. And so you need to gather as much information as you possibly can, as all of us are prone to try to do when we're going to make a decision, especially a decision about someone's liberty in a situation that could result in additional harm to another person.
In all of your work in Cleveland, did you ever have initiatives that were related to victim services? Or you mentioned DV briefly and the dangerousness hearing process for that, but were there any other victim-focused initiatives you worked on?
Well, my whole career, I was really kind of a person who leaned towards trying to reduce levels of violence in the community. So there were a lot of things that I did that had as at their core violence reduction. Probably the one that I'm most proud of is that we brought a family justice center to Cleveland, and I spearheaded that effort. And a family justice center really is just a one-stop shop to provide individuals who are involved in domestic and intimate partner and other kinds of violence that involves interpersonal relationships, can get all of the things that they need to get done in one fell swoop, rather than having to run all over town. We had determined that on average, someone who had to leave their home because of the violence that they were experiencing had to go through something like 20 or 21 separate appointments with various agencies just to get back to square one. So with the Family Justice Center, it's like, you speak once, it gets captured, and then it's shared with all the agencies that you need to interact with without you having to go to all of the different places in order to get that done.
So George, I wanted to move on to the topic of diversion. As you obviously are aware and have alluded to, most counties don't have the resources to immediately implement this extensive pretrial programs and risk assessments or staff agencies in their counties. What are a few things that counties can start doing now to begin diverting people, appropriate people, of course, away from jails and away from incarceration?
Well, as I said, the initial change that we made didn't cost us a cent. We just sat down and unless you want to talk about the amount of time that I spent putting it together, and of course my time is valuable, right? But other than that, I sat down and put together a pilot. And I really put together the pilot based upon information that I had as it related to other jurisdictions, and took a leap of faith, because there was no jurisdiction that I was aware of or that I was able to discover that had a negative kind of experience by trying to allow people who were low risk uh, types of individuals out on bail while their cases were pending. And in an age of pandemic, I think that this becomes even more germane, because keeping people in jail is likely to cause a super spreader event. So anything that we can do to get them out of jail more quickly, that's not going to increase the risk that they're not going to come to court when they have to, or increase the risk that they're going to commit additional criminal activity, ought to be something that we're looking at. And I think that most jurisdictions can be sold on doing this just on the economic side of it. The economics of reducing your jail population can actually provide the additional funds that you might need to bring about a pretrial services unit.
And Judge, do you have any thoughts, and it's fine if not, of course, but on diversion options that might be implemented before someone actually gets charged or before they end up in court at arraignment? So maybe it's sort of options that are available to road officers and other folks who encounter people very early in the process.
Well, I think a lot of jurisdictions are moving towards citations as opposed to arrest. And depending on what your jurisdiction's tolerance and risk tolerance is, that is probably one of the better things that people can do. Because again, if you're talking about folks that are low risk to begin with and low level to begin with, even if somebody doesn't show for court, you may miss out on the fine if they were able to pay it, but there is a higher probability that they will show than that they won't. And in the meantime, you won't have had to clothe them, feed them, and house them while you were waiting for them to come to court. And if you kept them employed, that means that there's money coming into the city or the county's coffers, as opposed to money going outside. So, I mean, just sitting down and actually going over the way that you go about doing business and whether or not what you're doing is really effective, I think is the first order when it comes to trying to assess what you want to do next.
So, Judge, I wonder if there's anything that we didn't cover that you wanted to impart to the audience. Again, this is mostly Tennessee stakeholders that will be watching this, but anything else that I didn't get to that you want to touch on about your experiences with pretrial?
I think that we probably have touched on most of it, but I would like to reiterate that pretrial reform and bail reform is a win-win situation. It's a win for the community. It's a win for the court system. It's a win for the individuals who come into the system. So I guess it's a win-win-win situation. And it is the kind of thing that we rarely see happen, where everybody can be better because of the fact that there were changes made to the way that we have traditionally done business.
Well, Judge, on that note, I think we'll wrap up, and I just want to thank you so much on behalf of the OCJP and CJI for spending time with us today. You're really a wealth of knowledge, and just can't thank you enough.
Thank you for having me. It's been my pleasure, and I've enjoyed it thoroughly.